Hello, how are you today? This is Bong Soo-jung, Korean labor attorney. Today I'd like to introduce legal standard working hours and contractual working hours. So what is a legal standard working hours? That means working hours that are stipulated in the Labor Standard Act. So Labor Standard Act Article 50 stipulate that weekly working hours cannot exceed 40 hours excluding recess hour. Daily working hours cannot exceed 8 hours excluding the recess hour. This is the legal standard working hours. So it stipulates weekly and daily working hours. 40 hours per week. Also 8 hours per week. They are the maximum the legal standard working hours. Also 1 week means the 7 days including the weekly holidays. That means the overtime can be allowed up to 12 hours for 1 week period. Then the maximum working hours are 52 hours, like 40 hours plus 12 hours per week. So this is the legal standard working hours for normal workers as a maximum. So employee cannot have their work more than those legal standard working hours. So both parties allowed, then overtime is allowed, but it is only up to 12 hours per week. So minor workers working hours, like minor means their age is more than like 50 years or old, or 8 years or less. Those hours are the minors, so their working hours are protected very strictly. So their daily working hour cannot exceed 8 hours. Also the weekly working hours cannot exceed 35 hours. So if both party, employer and minor, agreed on extension, then the 1 hour can be exceeded per day, 5 hours can be exceeded for the weekly working hours. So maximum will be 35 hours per week. So also regarding the legal standard working hours for harmful and hazardous work. So those work are protected by the Occupational Health and Safety Act, the article number 139. So it stipulates so daily working hours cannot exceed 6 hours. Also weekly working hours cannot exceed 34 hours. So those jobs cannot be allowed for overtime. So those hours are the legal standard working hours. So what is a contractual working hours? That means so working hours that within the legal standard working hours, employer and employer agreed to work. So those hours are mutually agreed working hours between employee and employee, but those contractual working hours cannot exceed the legal standard working hours. That means 40 hours per week, 8 hours per a day. So why the contractual working hours is important is Article 17, employment contract must compose basic working condition like wage, working hours, and weekly holiday, and also holidays, week holidays. So in that case, before year 2007, so it only stipulate wage and working hours, but from year 2007, contractual working hours was introduced in this component of the employment contract. So employer must have a wage and based on contractual working hours. So they cannot have working hours that including overtime. So that's very important. So from year 2007, employee cannot have an inclusive wage system for like including overtime. So it's not agreed. Only increased wage system is acceptable for the job that cannot be measurable for working hours. So normal working hours that can measure their working hours, they are not allowed to include the overtime in the employment contract, because wage should be decided based on contractual working hours. Okay, this is what I explained, like contractual working hours and legal standard working hours. Thank you for watching. Bye bye.